Okay, let's dive into this fascinating legal puzzle. It all starts with something that looks like a handgun on the street, but it ends up questioning the very definition of a firearm in the eyes of the law. So our story kicks off on a pretty specific day, April 23, 2010. You've got these private investigators watching a man, a Mr. Dunn, when they see something that immediately sets off alarm bells. He pulls what looks for all the world like a pistol from his jacket.
And here's the twist, right? The thing that makes this whole case so complicated. That object, it wasn't a typical firearm. It was an airgun. And as we're about to find out, that one little difference, well, it changes absolutely everything.
So let's really break down the incident itself. I mean, on the surface, it seems pretty simple, but the devil, as they say, is truly in the details here.
Here's how it all went down. While he's being watched, Mr. Dunn meets up with a friend and pulls out this object to show him. The investigators see this, and they're obviously concerned, so they call the police. The police eventually track down the object in Mr. Dunn's shed, and it turns out to be a Crosman Pro 77 airgun. Now, we need to take a closer look at this airgun, because this was not your average toy. It was specifically designed to look almost identical to a real 9mm pistol, and even came with this really stark warning label that said, "Not a toy, misuse can cause fatal injury." And critically, it had some serious power, firing BBs at over 261 feet per second. And that number, 261 feet per second, that is the absolute key. You see, a scientific study had already established that any projectile flying faster than 214 feet per second can cause a serious eye injury. Mr. Dunn's airgun was way over that line. So, objectively speaking, this thing was dangerous. Okay, so we've got a dangerous object that looks just like a real gun. You're probably thinking this is an open and shut case, but this is where our story takes its first huge legal twist. Believe it or not, at his first trial, Mr. Dunn was found not guilty. Yep. Despite how real the airgun looked, and despite the fact that it was powerful enough to cause real harm, the judge acquitted him of every single charge. Which, of course, brings us to the big question. How on earth is that possible? Well, to get it, we have to look at how the law defines two really important words. Let's start with the legal definition of a firearm. The criminal code says it's a barreled weapon that can shoot something capable of causing serious injury or death. But pay close attention to that very first word, weapon. Okay, now let's look at the definition of a weapon. It's anything used, designed, or intended to cause harm. But look at the very end of that definition. It says it includes a firearm. And there it is. That's the problem. To be a firearm, it has to be a weapon. But the definition of weapon points right back to firearm. It's a perfect legal loop. The trial judge got stuck in this exact loop. His logic was, since Mr. Dunn didn't intend to hurt anyone with the airgun, he was just showing it off, it didn't fit the definition of a weapon. And if it's not a weapon, well, then according to the law's own circular logic, it can't be a firearm. He was just following the precedent that was set in a case called R. v. McManus.
But the story definitely doesn't end there. The prosecution was not having it. They appealed, arguing that this whole interpretation of the law was creating a really dangerous loophole for public safety.
So the Crown appealed the decision. Their whole argument was that by focusing only on what the person intends to do, the law was totally ignoring how dangerous the object is by itself. I mean, if a powerful airgun is only illegal when you mean to hurt someone, what's stopping people from being reckless with them? And you can tell just how serious this question was by what happened next. The Court of Appeal put together a 5-judge panel to hear this case. That is a very rare move, and it's something they only do when a major legal question needs to be settled once and for all. So the appeal court was staring down a direct clash between two different legal precedents. You had R. v. McManus on one side, the case that said it's all about intent. But on the other, you had this binding Supreme Court ruling, R. v. Falalka, which basically said a firearm is always a weapon, no matter what you plan on doing with it. So how did the court untangle this messy legal knot? Well, they came at it with a really clear 3-step line of reasoning. First, they said, look, the Supreme Court's ruling in Falalka is the boss. We have to follow that. Second, they looked at the whole point of firearms laws, which is public safety. It just doesn't make sense to regulate dangerous things based on what someone's thinking in the moment. And third, they pointed out that if you read the law in that circular way, the phrase includes a firearm becomes totally pointless, which is a big no-no in legal interpretation.
This new way of thinking led the court to create a super clear, rational system for classifying these things. You can see it right here. They basically made 3 tiers. At the bottom, you have objects under 214 feet per second. They're not firearms unless you plan to do harm. At the very top, anything over 500 feet per second is always a firearm. Full stop. You need a license. But the real game changer was this new middle category.
Group 2. This is for objects between 214 and 500 feet per second. The court ruled that these things are legally firearms simply because they are capable of causing serious injury. And Mr. Dunn's airgun, at 261 feet per second, fell right into this group. Its capability, not his intent, was the only thing that legally mattered.
So this new reasoning didn't just flip the outcome of this one case, it actually reshaped Canadian law on this entire issue. The Court of Appeal officially overturned that old McManus precedent that the first judge used. They threw out Mr. Dunn's acquittal and ordered a brand new trial. And most importantly, they set a powerful new precedent. For an object like an airgun, what makes it a firearm is its built-in capability to cause serious harm.
And really, the court's decision brought everything back in line with that earlier Supreme Court ruling in Falauca. As Justice Corey wrote, a firearm, however, is always a weapon, no matter what the intention may be. The firearm itself presents the ultimate threat.
And all of this leaves us with a final, really important question to think about. By focusing on an object's potential for harm instead of the owner's intent, does this ruling strike the right balance? Is it the best way to ensure public safety while also regulating objects that millions of people own? It's a question that really gets to the heart of how we define risk and responsibility.